Students at the second floor, please kindly occupy your seats as fast as possible. Please be seated. I'm not sitting. I am standing there, down, wherever it is. Oh, huh.
Good morning. I said good morning. That's good. We'll be starting the program in next 2 to 3 minutes or so. We expect pin drop silence in the hall, and no movement in the hall will be allowed. I repeat what I said, when once the guest comes inside, movement inside the hall will not be allowed. Thank you so much.
Kindly keep the pathway free so that whenever the guests are arriving, the pathway is free. I will not announce. It is during the welcome, no? Welcome address only they will give the bouquet. So registrar will start. Yes. So he will have it in his... Yes. Okay. He will only say. I have no role.
Can you keep, you will be anywhere here. You give us a cue, like.
Yeah, you be ready. All the students should keep them ready. Kindly maintain silence in the hall. We are expecting our guest at any moment from now. Please do not move around in the hall. Kindly be seated. The volunteers whose work is done, please be seated. Please keep the pathway clear. The entrance and the pathway, please keep it clear. kindly do not move around. Wherever you're sitting, please be seated. First floor. They are on the way. The chief guest and other dignitaries are on the way. On my cue, everybody can rise in your seats and welcome them with a huge round of applause. Please maintain silence. Please maintain silence. Thank you. They're arriving. We all can rise in our seats. Let us, with a huge round of applause, welcome Professor Dr. M.R. Doraiswamy sir, Honorable Chancellor of PES University, along with the chief guest of our day, Honorable Mr. Justice B.V. Nagratna, Judge Supreme Court of India, and other dignitaries including Dr. K.S. Sridhar, Professor D. Jawahar, Honorable Pro-Chancellor of PES Group of Institutions, accompanied by all deans, directors, faculty members, and other members of the staff. Ladies and gentlemen, it gives us immense pleasure and pride in welcoming all of you to Juris Conscientia Law Summit 2023, organized by the Faculty of Law, PES University, Bangalore. As Aristotle has once said, educating the mind without educating the heart is no education at all. PES Group of Institutions believes and delivers value-based education and a world-class curriculum which gives the students the best launching pad to become the leaders of tomorrow. We try to instill in the students not just learning, but application-based experiential learning which makes them future-ready professionals. The mottos of perseverance, excellence, and service as given to us by our founder chairman, Professor Dr. M.R. Doraiswamy sir, is what we uphold in all our endeavors at PES. Let us start the function with invoking God's blessings. May I invite Ms. Kirti Sheshadri from Faculty of Law for the invocation song.
वसिष्ठवामदेवादिवन्दितमहागणपतिं मनसा स्मरामि वसिष्ठवामदेवादिवन्दितमहागणपतिं महादेवसुतं महादेवसुतं गुरुगुहनुतं महादेवसुतं गुरुगुहनुतं मारकोटि प्रकाशं शान्तं मारकोटि प्रकाशं शान्तं महाकाव्यनाटकादिप्रियम् महाकाव्यनाटकादिप्रियं मूषिकवाहनमोदकाप्रियं महाकाव्यनाटकादिप्रियं मूषिकवाहनमोदकाप्रियं महागणपतिं मनसा स्मरामि वसिष्ठवामदेवादिवन्दित महागणपतिम्
Thank you, Kirti, for that melodious rendition. Let's now have an ode to the state of Karnataka, its glorious history, culture, tradition, great children of the soil, which was gifted to us by Rashtrakavi Kuvempu. I request Ms. Nagashri Ms. Sharanya, and Ms. Varshini, students of Faculty of Law, to come and recite the Nadagite.
ಗಂಧದ ಚಂದದ ಹೊನ್ನಿನ ಗಣಿಯೇ ರಾಘವ ಮಧುಸೂದನರವತರಿಸಿದ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಜನನಿಯ ಜೋಗುಳ ವೇದದ ಘೋಷ ಜನನಿಗೆ ಜೀವವು ನಿಂದಾವೇಶ ಹಸುರಿನ ಗಿರಿಗಳ ಸಾಲೆ ನಿನ್ನಯ ಕೊರಳಿನ ಮಾಲೆ ಕಪಿಲ ಪತಂಜಲ ಗೌತಮ ಜಿನನುತ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಶಂಕರ ರಮನುಜ ವಿದ್ಯಾರಣ್ಯ ಬಸವೇಶ್ವರ ಮಧ್ವರ ದಿವ್ಯಾರಣ್ಯ ರನ್ನ ಶರಕ್ಷರಿ ಪೊನ್ನ ಪಂಪಲ ಕುಲಿಪತಿ ಜನ್ನ ಕುಮಾರ ವ್ಯಾಸರ ಮಂಗಳಧಾಮ ಕವಿ ಕೋಗಿಲೆಗಳ ಪುಣ್ಯ ರಾಮ ನಾನಕ ರಾಮ ನಂದ ಕಬೀರರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ತೈಲಪ ಹೊಯ್ಸಳರಾಳಿದ ನಾಡೆ ಡಂಕಣ ಜಕಣರ ನೆಚ್ಚಿನ ಬೀಡೆ ಕೃಷ್ಣ ಶರಾವತಿ ತುಂಗ ಕಾವೇರಿಯವರ ರಂಗ ಚೈತನ್ಯ ಪರಮಹಂಸ ವಿವೇಕರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಸರ್ವ ಜನಾಂಗದ ಶಾಂತಿಯ ತೋಟ ರಸಿಕರ ಕಂಗಳ ಸೆಳೆಯುವ ನೋಟ ಹಿಂದೂ ಕ್ರೈಸ್ತ ಮುಸಲ್ಮಾನ ಪಾರಸಿಕ ಜೈನರು ಧ್ಯಾನ ಜನಕನ ಹೋಲುವ ದೊರೆಗಳ ಧಾಮ ಗಾಯಕ ವೈನಿಕರ ರಾಮ ಕನ್ನಡ ನುಡಿ ಕುಣಿದಾಡುವ ಗೇಹ ಕನ್ನಡ ತಾಯಿಯ ಮಕ್ಕಳ ದೇಹ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಜಯ ಸುಂದರ ನದಿವನಗಳ ನಾಡೆ ಜಯ ಹೇ ರಸ ಋಷಿಗಳ ಬೀಡೆ ಜಯ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ.
Thank you. During the last 50 glorious years, the University of PES has helped and nurtured thousands of young women and men who have graduated from the university to nurture their dreams into reality. Let us now have a short look at the film on PES group of institutions. May I request my technical team to kindly relay the film on PES group of institutions. Faculty of Law in PES University was established in the year 2017 under the able guidance and patronage of Professor Dr. M.R. Doraiswamy Sir, Chancellor, PES University, with a vision of establishing a global law school. The Faculty of Law offers 5 years integrated programs spread across 10 semesters. We are proud to have an advisory committee of prominent judges and jurists headed by Honorable Mr. Justice Shri M.N. Venkatachalaya. Let us now have a look at a short film on the Faculty of Law, PES University.
PES group of institutions became the university, PES University in the year 2014, and we started our law school in the year 2017. Our law school is 6 years old now, where one batch is graduated. We have 2 programs, BA LLB as well as BB LLB. The students of law school are oriented in a way which we call here as agile. The entire curriculum which we have built in School of Law is based on the fundamental thought process of the service to the society, and we also have the fundamental thought process of building the ethical advocates for the nation building tomorrow. And we make a combination of the subjects in such a way that they will be strong conceptually and also they're strong contextually. The future for all our law graduates is into the litigation or into the corporate. And we really would like to see our alumni in one of the prominent positions in next 5 years to 10 years on the other side. The law school also has a great ambition, great vision of being in top 10 in the nation in next 3 years or so. And my entire team is working towards making this vision a realization in the future as such. So I'm sure with all these efforts, we'll be in the top 10 in next 3 to 4 years or so. Thank you so much.
Now, with a huge round of applause, let us welcome our chief guest and all the honorable dignitaries onto the dais. I request Dr. Shailashri Haridas, Advisor Faculty of Law, and Dr. Sujit P. Surendran, Associate Dean Faculty of Law, PES University, to escort our chief guest, Honorable Mrs. Justice B.V. Nagaratna Ma'am, Judge, Supreme Court of India, and our Honorable Chancellor, Professor Dr. M.R. Doraiswamy Sir, ex-MLC, Founder Chairman of PES University, and Advisor, Cabinet Rank on Education Reforms, Government of Karnataka, onto the dais. I also request them to accompany the other dignitaries, Professor Dr. D. Jawahar, Dr. K. Sridhar, onto the dais. May I now invite the person who has grown along with the PES institutions and contributed immensely to its growth, Dr. K. Sridhar, the Registrar of PES Group of Institutions and PES University, for the welcome address.
A very good morning to one and all present here, and a very warm welcome to this auspicious event this morning, March 6th, Monday. We have amongst us luminaries who have decorated the days, and it's indeed my proud privilege and pleasure to extend a very warm welcome to each one of them who have occupied the days. We have amongst us today Justice B.V. Nagaratna. Ladies and gentlemen, before I proceed, please put your hands together to wish and pray that she is going to be very likely become the India's first ever woman Chief Justice of the country in the year February 2027. Taking a closer look at her journey so far to the Supreme Court shows immense growth and perseverance. She began practice as a lawyer in the year 1987 in Karnataka, and after 2 decades of practice, she was appointed as an additional judge in the High Court of Karnataka in the year 2008. She was then elevated as a judge of the Supreme Court of India very recently in August of 2021. Her judgments, while as a judge of the High Court of Karnataka, made it to the headlines. Speaking of headlines, she was pictured in the news for slamming sectionalism in the media under the guise of breaking news. She had in fact proposed a regulation of the media in 2019, which stands to be another famous judgment. She held that temples are not commercial entities and therefore are not liable to pay gratuity under the Payment of Gratuity Act in 2021. Her independent and incisive thought to working judgments on 2 polarizing issues, namely demonetization and hate speech by elected leaders, is highly known. She also suggested few of her observations of political parties in her judgment holding demonetization as unlawful. In a short while from now, we are going to be witnessing a movie made on Madam Nagaratna to the benefit of all the people seated in this audience. It is indeed my proud privilege and prestige to welcome Mrs. Nagaratna to this august gathering today. A very warm welcome to you, madam, from all of us here. Dr. M.R. Doraiswamy. It's extremely difficult to describe this towering personality because he holds so much of distinctions to his credit. He is a household name in the field of education and a distinguished luminary who has devoted his life for the cause of education. Dr. M.R. Doreswamy started PES with just over 40 students in a rented gymnasium in the year 1972. And today, PES is one of the most sought-after institutions, not just in the country, but across the globe. He built PES with a lot of passion, commitment, and dedication, which we are all enjoying today as the fruits of his hard work. Dr. M.R. Doreswamy started his journey as a teacher, and let me tell this audience, he is also a lawyer by profession. Sir, thank you very much for your kind presence. He has been bestowed with numerous awards, including the prestigious Karnataka Rajyotsava Award for his immense contribution to the field of education. Some things which are very close to his heart are the adoption and the building of government schools. He started this more than 2 decades back, and today PES has adopted over 45 government and BBMP schools, not just in the city of Bangalore, but outside of Bangalore as well. Dr. M.R. Doreswamy saw to it that these children from government schools are not deprived of anything, be it good classrooms, good playgrounds, good furniture, library, computing facilities, and above all, training teachers to teach the students modern-day education. And very recently, during December 2022, a gala Vijnana Mela was arranged for over 100 government schools under his leadership, which went on very well and received wide acclaim for his contribution to this particular exhibition. This science exhibition saw immense benefit to the students of government schools, and none else than Professor C.N.R. Rao inaugurated this exhibition in December 2022. Professor M.R. Doreswamy was also featured in Guest of the Week, Varada Athithi, on Doordarshan Chandana, which was beamed on Friday and just last night at 8 p.m. It was really a pleasure to see Dr. M.R. Doreswamy speaking to the people of Karnataka on the featured program. Dr. M.R. Doreswamy also evinces keen interest, and perhaps we call him as the youngest man on the campuses of PES. It's indeed a pleasure working under him, knowing from him, and we regard him as a father figure in PES University. Sir, a very warm and affectionate welcome to you from all of us here. A wise man once said, "A leader knows the way, goes the way, and leads the way." This is none other than our own Honorable Pro-Chancellor, Professor Jawahar. Ever since his return from the United States of America after his post-graduation in 1991, he has championed and spearheading the quality initiatives at PES University. Perhaps the campus-wide quality improvement program was the first of its kind to be implemented in the university in 1991 itself. Professor Jawahar has a lot of energy, and Professor Jawahar is synonymous with quality. Nothing should escape his eye as regards quality is concerned. If you probably pay a visit to our Golden Jubilee blog, every corner, every place in the Golden Jubilee blog speaks of the involvement of Professor Jawahar to bringing it to that particular stage. We have had the proud privilege of interacting with him on a day-to-day basis, working under him and knowing from him. It's indeed my proud privilege to extend a very warm and affectionate welcome to Professor Jawahar to this gathering today. An alumnus of IIM Calcutta, an economist by profession and by passion, worked closely with government of Maharashtra and different national law universities, including the National Law University at the state of Maharashtra and the National Law University at the state of Gujarat, is none else than Dr. Shailashri Haridas, the Dean, Faculty of Management and Commerce. She has been spearheading all these programs in the last 2+ years, and it's indeed my pleasure and privilege to extend a very warm welcome to Mrs. Shailashri Haridas. Mr. Sujit Surendran, who is the Associate Dean of the Law Program of the University, is also present amongst us. A very warm welcome to you, Professor Sujit, from all of us here. I recognize the presence of Mrs. Aruna Devi, Chief Executive Officer of PES ITM Shivamogga. A very warm welcome to you, Madam. Sorry, Madam. Uma Devi, sorry, Madam, sorry, kindly excuse my ignorance. Mrs. Uma Devi, she is the CEO of PES ITM Shivamogga. I also recognize the presence of distinguished invitees, students from various programs of study, mostly from the Department of Law. I also recognize the presence of deans and chairpersons of various programs of study of PES University. It's indeed my pleasure to welcome you all for this event this morning. I also extend a very warm welcome to the members of the media, as well as the others present along with them. It's once again my proud privilege to have rendered this welcome address on this very important occasion. A very warm welcome to one and all present here. Have a good day and thank you.
Thank you so much, sir. On behalf of PES Group of Institutions, we would like to welcome Dr. K. S. Sridhar, our respected Registrar of PES Group of Institutions. I request Dr. Shaileshri Haridas ma'am to welcome Dr. K. S. Sridhar, sir, to the event. Now is a very important moment of the lighting of the lamp by our honorable dignitaries. I request all the dignitaries on the dais, our chief guest, Honorable Mrs. Justice B.V. Nagratna, Professor Dr. M.R. Doreswamy sir, Professor Dr. Jawahar sir, and all the dignitaries to join us in lighting the lamp. PES has always given merit at its importance. And today we are proud to give some special awards for meritorious scholarships for the students who have passed out from the Faculty of Management and Commerce in the year 2019. We are proud to say that till date, PES has given more than 35 crore awards in terms of meritorious scholarships to the students who have scored the top 10% across all the courses at PES Group of Institutions. Now, may I request our Honorable Founder Chairman and Chancellor, Professor M.R. Doreswamy sir, to present the awards to the meritorious candidates today. In order, Ms. Suprita V. I request Ms. Suprita V. to come on to the dais. A huge round of applause. These are our top 10 ranked students from the batch of 2019 under Faculty of Management and Commerce. Congratulations. Next, Ms. Kirtana N. Murthy. The applause should continue. Ms. Kirtana N. Murthy, again a student of 2019 batch. Most of these students have either been placed or are doing their higher studies. Next, Ms. Kiran R. Jain. A check of rupees 50,000 has been given as the award for the special category. Ms. Sandhya Bhatt B. Ms. Sandhya Bhatt. Thank you, ma'am, for doing the honors. Mr. Namit B.G. Ms. Dhanalakshmi. Ms. Dhanalakshmi. Ms. Bhanu A.P. Ms. Dhanalakshmi, Ms. Bhanu A.P. Huge round of applause to all the candidates here who have won the special award for scoring the top 10 ranks of the batch 2019. Ms. Pallavi V. Ms. Pallavi V. Congratulations. Ms. Mekhala G. Mekhala G. And Ms. Deepti L. Huge round of applause to all the students and also to PES and our founder chairman for instituting such meritorious scholarships for the students. We are blessed to get the opportunity to be a part of this PES family because of the great vision, passion, and untiring efforts of the founder chairman, ex-MLC and chancellor of PES University, Professor Dr. M.R. Doraiswamy sir. A great visionary, educational reformer, philanthropist, and above all, a great human being. It is because of his relentless work in the field of education that he was bestowed upon the responsibility of advising the government of Karnataka on education reforms. With a huge round of applause, let us together welcome Professor Dr. M.R. Doraiswamy sir for the presidential address.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Today I feel it is a great day in the history of the PES University. The reason is, it is not only the Golden Jubilee year, which we are celebrating throughout the year with various important events, but also we have in our midst today one of the very distinguished guests, a daughter of very illustrious former Chief Justice E.S. Venkatramaya, was her father. What a pleasure it is. She has stepped into the shoes of the great illustrious father E.S. Venkatramaya, that is Justice Nagaratna. We are very happy to have her from Karnataka in Supreme Court. That is the beauty of the I am fortunate to know them, both father and daughter and others in the family, from last 2 decades. ఏం చెప్పాలని తట్టలు Then these are all very, very rare things to happen in a man's life. And why I say distinguished guest, among the Supreme Court judges, there is only one lady, that is Justice Nagaratna, who represents Karnataka. Not only that, Karnataka can be proud. Shortly, she will be elevated to the Chief Justice of India. What a great opportunity and pride that every Kannadiga can have to have our own person as a Chief Justice of this great nation. She is here today, and she selected a subject, perhaps you are aware, the public interest litigations, whether it is a boon or bane for good governance. And along with her today, we saw on the dais, we are seeing Professor Jawahar, the Pro-Chancellor of the PES University, and the person who has taken a lot of interest in organizing this function, Dr. Shailastri Haridas. Let us give her a big applause. And we have our registrar, K. Sridhar, and among the distinguished invitees that we have today, along with others, Srimati Uma Devi. She represents PES Shivamogga and take lot of interest to have the same quality of education in that region of Karnataka. We are happy that she is here in midst of us. Esteemed faculty members, dear students, just in the Sridhar, when in his welcome speech he mentioned that I too was a student of law. If I were to continue as an advocate, I would have been a competitor to the Chief Justice, the justice that she is sitting in Riyadh. But anyhow, I am happy. It is not today, if not today, shortly, students who are sitting here studying law in PES University, I wanted you to take her as your role model. Dream such things. That is what Abdul Kalam says. Unless you dream some of these things, you cannot achieve. Every one of you should aim at to be achiever in the life. It is possible. I come from a village, a farmer family, with a determination, with a dedication, not only during the student days, even after that. Always I wanted to be an achiever. So the journey started by starting PES in 72, and we have reached Golden Jubilee celebrations, 50 years. That is the thing. When a village boy can do all these things, studied in a government school, and I know the students who are sitting here, you are all from, most of you are very prestigious schools, prestigious colleges, and you are here in a prestigious university. What else? What else you want? And apart from it, you have perhaps the facilities are concerned, the best facilities that any law student can think of, either in the terms of library or in terms of staff and all that. With all these things, every one of you should aim at achieving something very great in your lifetime. One or two things I wanted to mention, I don't want to take much of the chief guest's valuable time. One of the very important things that as a citizen of this country I am feeling. So far the judiciary is concerned, the very, very important organization that we have, and crores and crores of people have hopes only as a last resort. What is the last resort of this? From farmer to the multi-millionaire, if there is an injustice, it is only the judiciary. It is only they seek justice. So it is a very interesting, exciting, amazing development that is taking place in the area and scenario of judiciary in this country. There is a huge development, as you know, the increase in population. Perhaps we are not able to cope up with the increase in population, not only increase in population, but increase in litigations. Perhaps I was just thinking, when a literacy percentage increases in a country, the litigation should come down. But on the other hand, what is happening in the country, the percentage of literacy is increasing and the litigation number is equally increasing. There is according to the information I have, which is available in the public domain, that we have around 5,000 crores of litigations in different levels of courts in India. One of the reasons there is a shortage of judges. We have 6,000 shortage of judges district courts, high courts, and Supreme Court. That may be one of the reasons why there is a delay in delivery of justice or getting the justice. However, it is a challenging job to people like Justice Nagaratna, who is quite aware what is happening, what is going on, how people are desperated, and how people have to wait just decades and decades to get justice. This situation cannot be continued like this, because people should not lose confidence in judiciary. Measures has to be taken and see that justice is delivered to the people. She is a very upright, outspoken, original, her judgments, those who are familiar. I am not going to cite too many things, but one of the very, very important judgment, that dissent note, she has a courage to give the dissent note in the Supreme Court regarding the denotification of currency. She could be able to give her own views about it. It is not easy. She has quoted not only just, she gave a dissent note, she has given a reasons why she is giving dissent note. We need this kind of judges with a independent thinking and stature. Similarly, there are several landmark judgments which just show her dynamism and her depth of knowledge and concern to the society, concern to the nation. It is a great opportunity to every youngster who is sitting here to listen to her. Equip yourself. And lastly, only one thing I wanted to say and end my speech. I wanted you, don't aspire to getting into the corporate sector, attracted by the high salaries and all that. I wanted to see the PES University products of law, making a name and fame in practicing in High Court, Supreme Court, and different courts. Again, making a name, preparing yourself. I always feel nothing like preparing, arguing your case before the judge. Winning or losing is secondary. But if you could able to put forth your views effectively, to put forth effectively what is required, again, you must be very effective communicator. The former Chief Justice E.S. Venkatraman always used to tell, an advocate need not confine to only to study law books. An advocate should have a wide reading. What is required is wide reading. It may be literature, it may be any other thing. Wide reading is very essential. I believe in it. All of you should have wide reading. You have a best library, wide reading, equip yourself, have a fund of knowledge, not only in law, related to the law, and make a name and fame. And tomorrow you must be the competitors to the every highest judiciary post that we have in India. Thank you very much.
Thank you, sir, for being our inspiration and guiding light. On the eve of Women's Day coming up on March 8th, who better to have to inaugurate our Juris Conscientia than Mrs. Justice, Honorable Mrs. Justice B.V. Nagaratna ma'am, Judge Supreme Court of India, who has taken out time from her busy schedule and agreed to grace this function. Before inviting our chief guest for the address, let us have a look at a short film on the life and work of Honorable Mrs. Justice B.V. Nagaratna.
With the news emanating out of the country's highest court, one name stands out the most in 2023, and that is the name of Justice B.V. Nagaratna. Her ladyship's name is initiating significant media coverage courtesy of her ladyship's inspiring endurance, passion and devotion towards the profession. Justice B.V. Nagaratna is the daughter of the former Chief Justice of India, Honorable Justice E.S. Venkataramaya. We all await with bated breath as her ladyship's likelihood of becoming India's first female Chief Justice in February 2027 is fast approaching. Her ladyship is currently fifth in line behind the current Chief Justice of India, Justice D.Y. Chandrachud. A closer examination of her ladyship's rise to the Supreme Court reveals tremendous perseverance and progress. Her ladyship began her legal career in Karnataka in the year 1987 and was designated as the additional judge of the High Court of Karnataka in 2008. After nearly 2 decades in the profession, her ladyship was then elevated to the Supreme Court of India in August 2021. Her ladyship's judgment while as a judge of the High Court of Karnataka have never failed to make it to the headlines. Her ladyship was recently observed denouncing sensationalism in the media. In reality, her ladyship suggested media regulation in 2019, which became another well-known decision. Her ladyship has also ruled that since temples are not commercial entities, they are not required to pay gratuity under the Payment of Gratuity Act, which is a celebrated decision. In 2021, her ladyship brought the Karnataka government to task, demanding that midday meals be reinstated in schools and declaring midday meals to be a fundamental right. Her ladyship's independent and incisive thinking on 2 polarizing matters, demonetization and hate speech by political officials, is well recognized. Her ladyship included key limitations in her decision and underlined in her judgment how hate speech is a cause for concern and how it strikes at the core of a diversified community like India. Her ladyship maintains that hate speech undermines the basic foundations of solidarity, equality and tranquility. She also admonished prominent personalities that, given their immense power over the masses, owe it to be controlled and measured in their remarks. Legal scholars have already been comparing her ladyship to renowned judges of the past who were well known for questioning the constitutionality of the government's activities at the time. We are honored to welcome Honorable Mrs. Justice B.V. Nagaratna to Juris Conscientia.
With a huge round of applause, let us welcome our chief guest, Honorable Mrs. Justice B.V. Nagaratna, for the inaugural address.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. Professor Dr. M.R. Doreswamy, Honorable Chancellor and Founder Chairman PES University. I have known him quite a while. He was my maternal uncle, Sri Shivaram's classmate. And because of that connection, I think he also attended my wedding reception. Because at that time, one of my cousins was studying in PES College and he had invited him. Professor D. Jawahar, Honorable Pro-Chancellor, Dr. K.S. Sridhar, Registrar, Dr. Shailashri Haridas, Dean, Faculty of Management and Commerce, PES University, Dr. Sujit P. Surender, Associate Dean, Faculty of Law, PES University, members of the management and faculty of PES University and Faculty of Law, distinguished invitees, Srimati Uma Devi, who has come all the way from Shimoga, my cousin Sri Ramakant, and Srimati Dr. Anuradha M., his wife, who is in the PES University. Dear students who are here present in large numbers to inspire me to speak, members from the media, ladies and gentlemen. I thank the PES University and particularly the law faculty for inviting me to this first Juris Conscientia, the law summit of 2023, and to inaugurate it, particularly by the Faculty of Law, which has invited me. I'm happy to note that PES University is celebrating its Golden Jubilee. I extend my congratulations and warm greetings to the university. It is very difficult to have education spread in a country like ours. Professor Dr. Doreswamy just now mentioned that he came from a village, studied in a government school, but he has always had a vision, and it is always that vision, as he said, that you must dream. His dream and vision has taken him this long, and I'm sure that the PES University will celebrate not only its Golden Jubilee, but its centenary and many centenaries. I extend my congratulations and greetings to the PES family. Now, before I go on to my actual subject, I must say that the student audience here, majority of them are lawyers to be or advocates to be who are studying law. So my first small advice to them is to consider what you want to do in law. Of course, you are all now law students, but the subject of law has vast avenues nowadays, unlike when we were studying and we could either go to become a lawyer and ultimately aim to be a judge, but that is not the way now. You can become an advocate, go into the litigation side. You can become a mediator with your knowledge of law and training as a mediator. You can go to the district judiciary, or you can aim to become a high court judge and later a Supreme Court judge. You can go to the corporate world, or you can teach and go to the academia. My sincere advice to all the law students gathered here is, even when you are going to the senior classes of your law studies, try to focus on what exactly you want to do in law. Law and technology is a vast area now. You can become, editors, you can start your own blogs, you can have your own, what you call e-versions, magazines, etc. So there's a vast opportunity, and I'm sure your university will expose you to all these various aspirations that the young advocates, young students may have here, so that you could focus on what exactly you want to do after your degree is completed. Another small advice I wish to give to our young friends here is that don't just think about your village, your town, your city, but think about the nation and think about the world. You are the future citizens, the future of India, the future of the world, and everybody is looking up to you, particularly the lawyers, the advocates. So always have the nation in mind. Know the history and geography of our country. As your Chancellor just now said, don't restrict your reading to law books, but read a vast variety of literature, history, geography, science, whatever you want to read, technology, human rights, so that you become well-rounded and not just bookish in law. This is another small advice I have. And with the small heart-to-heart talk, I must say, with the young lawyers to be, I will go on to my subject which I have chosen for this colloquium or law summit, which you may call, on public interest litigation, boon or bane for good governance. Now, we all know that we as citizens, we would all like to have good governance. Governance from the executive, governance from the various levels of governments and authorities, and justice from the judiciary, and good laws from the parliaments and the legislative assemblies. What is good governance? The expression good governance has several connotations, and the ideal can be achieved or realized in many ways, but the goal is singular. The term centers on the responsibility of government and governing bodies to meet the needs of the masses as opposed to a select group of the society. In a nutshell, good governance entails effective participation in public policy making, the prevalence of rule of law, and an independent judiciary, besides a system of institutional checks and balances through horizontal and vertical separation of powers and effective oversight agencies. Good governance has always been a theme in our Indian history, as it is fundamental to our socio-political existence. According to Kautilya's Arthashastra, the purpose and nature of exercise of sovereign power has been pithily summed up, and I quote, "In the happiness of his subjects lies his happiness," that is, the sovereign power or the king those days. "In their welfare, his welfare. Whatever pleases him, he shall not consider as good, but whatever makes his subjects happy, he shall consider good." The essence and basis of good governance, as per ancient Indian thinking, is governance which would secure happiness to all, as denoted by the expression, "Sarve bhavantu sukhinah." As per the United Nations Commission of Human Rights notion of good governance, the attributes include transparency, responsibility, accountability, participation, and responsive to the needs of the people. Good governance is just linked to an enabling environment conducive to the enjoyment of human rights. As per the World Bank definition in the 1986 to 1991, they said good governance is public service that is efficient, a judicial system that is reliable, and an administration that is accountable to the public. In 2012, the World Bank redefined good governance to mean participatory governance, consensus-oriented, accountable, transparent, responsive, effective, and efficient, equitable and inclusive governance which follows rule of law. Thus, the golden thread in all these definitions of good governance is rule of law when enforced impartially by protection of human rights and enforcement of fundamental rights, while at the same time curbing maladministration or non-administration, and generally resulting in the enforcement of goals of the Constitution and laws throughout the country. Now, for an audience like this, which is studying law and to be the future lawyers of this country, I need not go in depth about the two important features of our Constitution, namely the fundamental rights in Part 3 and the directive principles in Part 4. The directive principles, though not justiciable, they are always fundamental to the governance of the country, while fundamental rights secure our freedoms and the socio-economic rights are secured through directive principles. Rule of law is considered not solely as an instrument of the government, but as a rule to which the entire society, including the government, is bound. Thus, the rule of law is fundamental in advancing democracy. The rule of law, defended by an independent judiciary, plays a crucial role by ensuring the civil and political rights and civil liberties are safe and the equality and dignity of all citizens are not at risk. Now, you all must have read about public interest litigation in your law dealing with administrative law, or while dealing with constitution, or you might have read it as an independent topic by itself. Now, what is this public interest litigation? In America, it is called social action litigation, while we always say representative action. We always have had representative action in our CPC, where a group of people can file a suit for the good of a community, that is society, the village, the town, or the city. But in the 1980s, the Supreme Court, presided by the then Chief Justice Chandrachud, Y.V. Chandrachud, whose son, illustrious son, Dr. D.Y. Chandrachud is our present Chief Justice, opened the doors of the Supreme Court to what is known as public interest litigation, to remove injustices in society, to ensure that the government, which has by its actions or omission not acted on the right path, is corrected through the judicial mechanism. Hence, PIL, or public interest litigation, is the incarnation of the court through judicial activism and its people-oriented litigative dimension. People now know that the constitutional courts, whether the high courts or the Supreme Courts, have the power of intervention. It is usually under Article 226 as far as the High Court is concerned, and Article 32 as far as the Supreme Court is concerned, to have their rights asserted and enforced through constitutional interventions, which can be invoked to ameliorate the miseries arising from repression, governmental lawlessness, and administrative deviance. These concerns are said to be remedied by rather extraordinary remedies by the courts, which, to the degree permissible under the constitutional scheme, sometimes shifts the line, or we often say the Lakshman Rekha, so to say, between adjudication and legislation on the one hand, and administration and adjudication on the other. However, I can confidently say that such cases have brought a new debate or dialogue on the role of constitutional courts in a dynamic society such as ours. The concept of PIL was greeted in India with an understanding that important rights are not always individual, but diffused and meta-individual. The Indian Supreme Court, as well as the high courts in the country, have realized the dismal social problem, that is lack of access to justice to the poor and oppressed, and have used this as a springboard for building a strong tradition of voluntary social action by empowering voluntary representatives to approach the court on behalf of the poor and the oppressed, or any class of affected persons by PIL. When a case is normally filed, it is done in terms of the procedure which is envisaged. Now, if you want to file a suit, you have to file it under Section 26, read with Order 7, Rule 1, by filing a plaint. Then you file a written statement under Order 8, Rule 1 of the CPC. If you file the writ petition, you file it through the writ procedure rules in the high courts and the Supreme Court rules in the Supreme Court. But PIL has opened the doors to the public, to the common man, who can just simply write a letter to the court, and that letter, if it merits consideration, can be treated as a writ petition. procedure, which is a handmaiden to justice, has been relaxed by the Indian judiciary when it comes to the PIL. A postcard, a newspaper writing, or any other kind of material which comes to the Supreme Court or the High Court's notice can awaken the eyes of the Supreme Court to the problems and hence take it up as a suo motu writ petition. As a result, a new brand of socio-legal engineers have emerged who treat the court as their resort through a pro bono publico and a social commitment by filing such petitions. I'll not go into more details of all those as you would read it in any book or chapter containing public interest litigation. But what is important is that the procedure has been relaxed within the framework of the law when it comes to public interest litigation. The court has begun to suggest and decree elaborate schemes which were in some instances directly monitored by it through specially appointed committees. In relation to such procedural innovation, the Apex Court in Bandhava Mukti Morcha, speaking through Justice P.N. Bhagwati, has said, the constitution makers deliberately did not lay down any particular form of proceedings for enforcement of fundamental rights, nor did they stipulate that such proceedings should conform to any rigid pattern or straitjacket formula. Now, what is this creative adjudication through the mechanism of PIL? I will deal with it in phases, and I will also say how the orders of the Supreme Court or the High Courts in public interest litigation has ultimately helped the government to come out with various measures for the benefit of the common man. The first phase of Indian PIL was with regard to the conditions in prisons and other places of detention. The focus initially was on prison reforms and to curb the repression by agencies of the state, notably the police, prison, and custodial authorities. Therefore, we have those long list of cases, Husainara Khatun, Sant Bir, Sheila Barse, and Professor Upendra Bakshi, Vishal Jeet, etc., where the court looked at as an agency which would enable citizens to combat repression and government lawlessness. The court considered itself with social justice, including exploitation of bonded labor, work and pay of unorganized workers, poor peasants, etc. The early PIL was predominantly with regard to the failure of the criminal justice system in India. But gradually there was a new paradigm shift to human rights and citizen-oriented profile of judicial power. The effort of the court was focused towards emancipation of the voiceless and powerless from exploitation and oppression in the context of good governance and fundamental rights of the citizens. Then we move on to the second phase of PIL, which was to promote social and economic rights. In People's Union for Civil Liberties, PUCL versus Union of India, the court expressed its anguish with regard to starvation deaths and the inadequate system of food security, and said that fundamental right to life included the right to food, and disregarded the plea of the government concerning lack of resources. As a result, there were many schemes which were initiated by the government, such as food grain subsidies for the poor, midday meal program in schools, Integrated Child Development Services Plan, ICDS, which also included immunization, nutrition, preschool education programs, and ultimately the prime example of the dynamism of the Supreme Court under Article 21, right to life includes the right to food, made the Parliament enact the National Food Security Act of 2013. Similarly, we have public interest litigation with regard to the right of the public to government information. And there has been the first judge's case in S.P. Gupta versus President of India, where it was observed that the concept of open government is the direct emancipation from the right to know, which seems to be implicit in the right of free speech and expression under Article 19(1)(a). The court's decision enabled the Parliament to enact Right to Information Act of 2005, where there is importance of transparency and openness to governmental affairs. Similarly, we have the Olga Tellis case, which you might have all heard of, Olga Tellis versus Bombay Municipal Corporation, where the Chief Justice Y.V. Chandrachud said that the right to life under Article 21 means the right to livelihood, and therefore persons who are living and selling, doing commerce on the footpaths and they had a means of living which could not be deprived except in accordance with law. As a result of these kind of directions, the Supreme Court has virtually rendered the fundamental right to life a repository of various human rights. Thus, we have the right to human dignity, right to healthy environment, free education up to 14 years of age, emergency medical aid, etc. The judicial activism with regard to right to education has ultimately culminated in introduction of Article 21(a) as a fundamental right in the Constitution in 2002, and the Right of Children to Free and Compulsory Education Act 2009. These cases are illustrative of the fact that the court's interpretation have converted formal guarantees into positive human rights. I next move on to what are called the environment pollution cases. We have the famous MC Mehta versus Union of India, where environmental pollution and industrial hazards were not only considered as potential civil torts and violations of fundamental rights, which could be redressed by the Apex Court through PIL. The Apex Court has compelled on various occasions closure of industries polluting environment by toxic emissions or discharge of hazardous effluents, ban on felling of trees except in accordance with the guidelines, prohibiting operation of shrimp culture in ecologically vulnerable areas, conservation and protection of natural resources for future generations, and adoption of the polluter pays principle and precautionary principle as part of Indian environmental law. In all these cases called PILs, what has happened is the right to represent and file such a litigation, which we call the doctrine of or the principle of locus standi, or the citizen standing, has been relaxed. Now we all know only if a person is aggrieved or has a cause of action, he can move the court for redressal of his individual grievance. But in a public interest litigation, the individual who files it has no interest in the litigation. He is doing it for a cause, for a public interest, and therefore his locus, his right to file such a litigation has been recognized by the Supreme Court in the first judge's case, that is S.P. Gupta versus President of India. The threshold question in order to entertain a PIL filed by a citizen is whether sufficient public injury has been caused to support the claim that the petition has been made in public interest. For instance, in the first judge's case, the petitioners therein claimed to be vindicating public interest in securing the independence of judiciary from political influence. In the said case, the court identified the potential public injury as the loss of faith in the rule of law and as a consequence, loss of confidence in democratic institutions of government. Such an exposition on the locus standi doctrine, in my view, marks a significant expansion of the court's role from being a protector of the individual rights to the guardian of rule of law, even when the same is threatened by the political executive. I must say that the concept of PIL, gradually modeled by the Supreme Court, has disciplined and conscientized governance in the country. Moving on, there are instances where the Supreme Court intervened in laying down guidelines towards independence and autonomy of the CBI in the context of Vineet Narayan versus Union of India. In Manohar Lal Sharma, the court declared coal allocation between the years 1993 and 2009 as illegal and arbitrary. And in D.K. Basu versus State of West Bengal, PIL was identified as a public weapon for the enforcement of public duties where executive inaction or misdeed resulted in public injury. Through the next segment, I will speak about how PIL, through the judicial system, has assisted governance and the Constitution. The post-1990 saw the policy making and legislative function of the court, which is not usually its domain. Policy making is the domain of the executive. Legislative function is the domain of parliament. But when both these organs of the state had not acted, the Supreme Court rose to the occasion, and in Vaishakha versus State of Rajasthan, the court promulgated regulations governing sexual harassment at workplace by invoking its exclusive jurisdiction under Article 142 of the Constitution. The Supreme Court said that the regulations which were framed by it would prevail until the Parliament would come up with a law. Vaishakha or Vishakha's judgment was in 1997. Ultimately, the Parliament came up with a law in 2013, and that is pursuant to the elimination of all forms of discrimination against women, that is CEDAW, to which India is a signatory, in coming out with the prevention of sexual harassment in workplaces in the year 2013. Further, in Lakshmikant Pandey versus Union of India, we find yet another example of the Supreme Court stating that adoption by foreigners should be regulated, especially with regard to adoption of foreigners by Indian children. Various guidelines were issued, and ultimately it was only in the year 2000 and thereafter in the year 2015 we have Juvenile Justice Care and Protection of Children Act, which is with regard to, amongst other things, regulation of adoption of Indian children by foreigners or concerning inter-country adoption, which is in accordance with the Hague Convention on Protection of Children and Cooperation in respect of inter-country adoption, 1993. The court in 1990s also took up the case of Vineet Narayan, where the court adjudicated the PIL that challenged the failure of the CBI to investigate and prosecute several prominent politicians who had been implicated in money laundering or the Hawala scandal. The court invoked its jurisdiction under Articles 32 and 142 to issue directives to the CBI to be autonomous by delinking itself from political control. I may say that independence of such bodies which are autonomous is very basic for having rule of law in our country. It was observed that the court's power to issue directions which carried the force of law had been recognized in a series of cases, and that it was capable to fill the vacuum till such time the legislature stepped in to cover the gap or the executive discharged its role. The Supreme Court in Vineet Narayan became the foundation case for the forum's willingness to function as a bulwark against corruption in higher places. Similarly, in Samaja Parivartan Samudaya versus State of Karnataka, which is a public interest litigation which is pending before the court, court-monitored investigation into deep-rooted corruption cases has become an institutional feature of anti-corruption litigation. The question before the court is with regard to the ongoing investigation by the CBI in relation to illegal mining, particularly in the state of Karnataka. In this connection, two types of abuses are being addressed. One, the state's authorities' actual abuse of power in allowing illegal mining contrary to the previous orders of the court. And second, the likely abuse that would ensure from the lack of fair investigation, giving complicity of public officials. These cases demonstrate the role of Supreme Court as a responsive site of anti-corruption activism. Further, linked to illegal mining and the protection of environment is the wide spectrum of environment litigation, where the Supreme Court has been willing to assume wide powers and this is in the absence of regulatory measures being implemented by those who are vested with such powers. In Sriram fertilizer case, the court permitted a chemical plant to be reopened after a gas leak only upon satisfying a set of stringent conditions. The Taj Mahal pollution case is also an important case where 292 industries had to either switch on to natural gas as an industrial fuel or relocate from the Taj Mahal trapezium area in order to protect the monument, namely the Taj Mahal. MC Mehta versus Union of India is again with regard to Ganga pollution cases by the tanneries, where the Supreme Court considered the closure of polluting units and justified its activism on the ground that statutory agencies of the state failed to prevent pollution of Ganga, which has resulted in a threat to the ecology and to the life and health of people residing nearby. The strong judicial sensitivity against the polluting industries was reflected again in MC Mehta, wherein it directed authorities to deny licenses to new hazardous industries having no provision of effluent treating plants. Then you all must have heard about the famous T.N. Godavaram case, where the Supreme Court defined what is the meaning of forest. It enlarged the scope of forest to mean as is found in the dictionary meaning or as per the government records or as per what is generally understood as forest. It initially began with felling of trees in the Nilgiris, that is near Ooty or Uttakaman, but gradually the case has assumed a mega proportion where the forests all over India have been considered protected by its orders. State by state, the Supreme Court takes up the cases and has passed orders for the protection and preservation of forests. Whenever I visit any forest, the first thing the forest officer would tell me is, "Madam, we are thankful to the Supreme Court. You have preserved our forests." In fact, my endeavor is that the Supreme Court must ensure that the forest cover in India must increase, the wildlife in India must increase, the fauna and flora must increase. Of course, for that, it's not just the directions which are important. What is called a corresponding implementation from the governments and authorities is also relevant. In view of this T.N. Godavaram's case, the Kudremukh mining in Kudremukh has been stopped. There is curb in the timber industries and prohibition of marble mining in Aravalis and regulation of sawmills. The Supreme Court has constituted what is known as the Centrally Empowered Committee to monitor and oversee the court's orders regarding use of forest lands, and as a result, there is also what is known as a forest levy being imposed called the net present value or the NPV, and use of forest land for non-forest related activity by payment of compensatory afforestation fund or CAMPA. PIL jurisprudence provides insights into the judiciary's role in securing accountability and transparency in governance by having far-reaching effects through its decisions. Courts have used PIL tools to assure timely policy intervention and also as a means to supervise and monitor governance. The reverse is also true. The directions issued by the Supreme Court have been well received by the governments, not only at the center, but by various states, as a means of strengthening their hands and ensuring that their policies are implemented. More recently, during COVID-19, we have all passed through this phase of COVID-19, which was about 3 years ago. The Supreme Court and the High Courts took up various remedy measures associated with the pandemic, including the containing of the pandemic by ensuring that the jails are decongested, hospitals and quarantine centers are established at a faster pace, rehabilitation of children who have lost one or both parents, and ensuring public health in the state and the nation. The COVID-19 management was given an impetus by various directions issued by the Supreme Court. When bills are filed, the process of the court cannot be abused for oblique considerations. Now, I have so far spoken about the good effect of PIL on governance, for ameliorating the problems of the people. They are all the boons of PIL, so to say. But what is the bane of PIL? I'll come to that aspect, which is the second aspect of my talk. The process of PIL cannot be abused for oblique considerations by masked phantoms who file PIL to secure a private end. Many petitioners nowadays masquerade as crusaders of justice. Often they are actuated by a desire to win notoriety or popularity, and the ultimate intent is to bring the wheels of administration to a halt by being spokes. In the Apex Court in Balco, Employees Union said that PIL is not a pill or a panacea for all wrongs, but PIL is a weapon to be used with great care and circumspection, and the persons who file these PILs must be also circumspect before the filing of the PILs, so that they, as petitioners, are not misused by certain vested interests for private gains. The courts also have to be extremely circumspect nowadays in entertaining PILs, because it could be out of vested interest, private malice, and without there being any public interest as such. PIL is an effective weapon for delivering justice to the citizens. It is for promoting good faith and preventing the law from crafty invasions. But it cannot be a weapon in the hands of vested private interests who appropriate such mechanism for the purpose of oblique motives. In Common Cause versus Union of India, way back in 2008, the Supreme Court regretted, and he said, and I quote, "Public interest litigation was initially created as a useful judicial tool to help the poor and weaker sections of society who could not afford to come to courts, has, in course of time, largely developed into an uncontrollable Frankenstein and a nuisance which is threatening to choke the dockets of the superior courts, obstructing hearing of genuine and regular cases which have been waiting to be taken up for years together. In order to ensure that the efficacy of the judicial system is not polluted, denuded, and consumed by an avalanche of misdirected petitions which are filed as PIL, the courts have now to scrutinize such PILs with great amount and degree of scrutiny, because they are filed sometimes to promote a personal, business, or political agenda. The legal community as a whole needs to be vigilant and carefully study such cases which are motivated by mala fide causes and not by bona fide feelings. The Supreme Court has cautioned on multiple occasions that PILs are now a camouflage to foster personal disputes rather than for public interest. That public interest litigation has sometimes now lost its essence, and it has become various other PILs, which I will now state. Kindly listen to them. Publicity interest litigation, private interest litigation, politics interest litigation, paisa interest litigation. All are PILs. See, when something good is there in the system, how the same can be misused in the name of that goodness by our citizens for their oblique private purposes. Anything good which is started by a government, any good scheme for the amelioration or for a socio-economic cause ultimately results in such kind of degradation, and PIL is no exception to this, I must say. It is important to ensure that PIL jurisdiction, which has been carefully carved out, created and nurtured with great care and caution by the courts, is not blatantly abused by filing some petitions with oblique motives. What is more disturbing is that before filing and after providing such petitions, a sustained press campaign is resorted to by the press to give it publicity, and such litigations are sometimes filed only for publicity. Very often, when a PIL is listed before a court, the persons who are behind this PIL, who want to achieve a particular end through a PIL, would often convey their feelings through the press. On the day the case is listed, there will be an article in the press on that PIL, so as to impress upon the court, not only through their advocates in the court of law arguing the matter, but by writing such articles or campaigns. Such kind of attempts dilute the very purpose for which the PIL was originally thought of by the Supreme Court and the constitutional courts. Another equally disturbing aspect is the misuse of PIL by hidden litigants. By hidden litigants, I would say that somebody would prop up another person who is only a name lender to file a case. This is because of rival business groups settling scores by resort to PILs, persons who describe themselves as public-spirited persons, or they usually call themselves as social workers, within inverted commas, social organizations which spring up overnight, file such cases. Hence, there is a warning from the Supreme Court that the courts must be satisfied with A, the credentials of the applicant who files the case, and B, the prima facie correctness or nature of information given to the court. Such petitions are increasingly being filed in relation to matters of projects of public importance, by unsuccessful tenderers, business rivals, and the use of public interest litigation for such type of motives must be curbed, nipped in the bud, and deprecated by the courts. The misuse of public interest litigation will stop only if the courts are vigilant. In every such case, the first question must be whether the petitioners are bona fide, whether the concern of the petitioner is real, or whether there is something more that meets the eye. In a recent judgment of the Supreme Court, it is not really recent, in 2010, the Supreme Court in State of Uttaranchal versus Balwant Singh Chaufal, 2010 3 SCC 402, has come out with a set of guidelines as to how the High Court and the Supreme Court must approach while entertaining a PIL. If frivolous PILs are filed, then such petitioners must be meted out with heavy costs so that there is no recurrence of such kind of PILs. The laudable concept of PIL was fostered and developed with a view to extend a long arm of sympathy to the poor, the ignorant, the oppressed, and the needy, whose fundamental rights are infringed and violated, and whose grievances go unnoticed, unrepresented, and unheard. This led to the dismantling of the traditional concept of doctrine of locus standi, as I said. PIL is a collaborative effort when the aim is not adversarial. The government and the state, through their government council, must collaborate with the court to ensure that appropriate directions are issued for ensuring good governance through the public interest litigation and the guidelines issued. In many cases, the representatives of the government or the authorities would say, please issue appropriate guidelines which will strengthen our hands in giving good governance in through various departments. But at the same time, I must say, as a self-warning, that the constitutional courts, including the Supreme Court and High Court, cannot give directions which cannot be implemented. We ourselves must also keep in mind the restraints which we have in issuing guidelines which cannot be implemented and therefore would remain only on paper. Therefore, a balance has to be struck while dealing with public interest litigations. While PIL is a potential for good governance through the judiciary and is a ladder to justice to disadvantaged sections of society, it cannot but contribute to good governance and for keeping the government accountable. With reference to the Indian experience, PIL could achieve many policy objectives. However, PIL has, at this juncture, should not become a backdoor to enter the temple of justice to fulfill private interests, settle political scores, or simply to gain easy publicity. Courts should also not use PIL as a device to run the country on a day-to-day basis or enter the legitimate domain of the executive and legislature. As I said, there is a Lakshman Rekha separating the three organs of the state. There may be times when that Lakshman Rekha is slightly shifted and the judiciary will take on the role of an administrator or as a legislator in various examples which I have given through my talk. This is only when there is a failure on the part of the governance or the governments at various levels in achieving the constitutional goals or the policy objectives that the Lakshman Rekha is shifted a bit. Otherwise, the judges are mindful of to what extent they can issue directions to the government and ensure that ultimately the directives which are issued by the court would lead to good governance in the country. The way forward, therefore, for India is to strike a balance in allowing legitimate PIL cases and discouraging frivolous ones by imposing heavy costs. One way to achieve this objective is to confine PIL primarily to those areas where access to justice is undermined by some kind of disability. The useful device of economic disincentives or costs to those who employ PIL for ulterior purposes must be applied regularly by the courts. Ultimately, it is the right judicial instinct and the skill of the judiciary which will stop the misuse of public interest litigation and restore it to the pristine and useful character to which it should be, and as to how and when it started. On this note of balance being restored in PIL, I once again thank PES University and particularly the Honorable Chancellor for inviting me to deliver this lecture on this topic. I hope I have not tested your patience, and I must know when to end. I thank you all for your kind attention. Thank you.
Just take a couple of questions. Oh, let us see. Yeah, you'll sit there.
Yes, yes.
Thank you, Your Ladyship, for your insightful address. I'm sure she's a role model to all the young budding lawyers who were listening to us, to her here today. And with your permission, Your Ladyship, we may move on to the question and answer session.
To the extent I can answer.
Yes, sure, sure. So we now move on to the question answer session. I hope the volunteers are ready with the cordless mics. Yes. First question. Over to you. Please be brief, to the point questions. Yes. Can we have another mic, please? Yes.
You take this.
Greetings of the day. I am Geetashri from 5th year, and my question is addressed to Honorable Justice Nagaratna ma'am. Your Ladyship, as of 2022, there are over 5 crore pending cases in the courts across various levels of judiciary. What is your view on establishing special courts to address the petitions relating to public interest litigation to reduce the burden of the cases?
See, public interest litigation is only an avatar under Article 226 or Article 32, as I said. They are along with the other stream of private interest litigation. We need not have special courts for public interest litigation. It is part of the entire, domain of litigation. And I don't think that there is a need for a special court for PIL because, as I said, PIL is invoked in extraordinary circumstances, whereas private litigation is the routine before the courts. So they can also be entertained by the regular courts, that is the High Court and also the Supreme Court. There is also what is called a suit which can be filed in a representative capacity before the competent trial courts in the districts. So I don't think there is a need to have a separate PIL court as such. It is only a kind of litigation. Yes.
Thank you, ma'am.
Welcome.
Thank you, ma'am. Can we move on to the next question, please?
Greetings to Honorable Justice Nagaratna ma'am. I am Madiha Mai from 4th year. Your Ladyship, what is the one advice you would give to young female advocates who aspire to be judges in the future?
See, firstly, my advice is to all lawyers to be not just, please sit down, not just to female advocates or women advocates. My advice is that your reading does not stop the moment you get the degree of law. In fact, that is the beginning of your reading. You need to read for every case and for every new law that is brought about. Even in the Supreme Court now, at the age of 60, I am reading so much to learn so much more of law, because law is as vast as life, and nobody would know every nuance of law. So my first advice to all future lawyers is, please start having the habit of reading. You read not just your case brief, but you read the commentaries, you read books, you read newspapers, read as much as possible. As far as women lawyers are concerned, I know there is a special problem. You see, we have, first of all, very few lawyers we had initially. Therefore, very few women became judges. Even now, we have very few women as judges in the Supreme Court and the High Courts. But in the district judiciary, we have more and more women coming up. It is a fact of life that women have not only the family to look after, if they are married or even otherwise, they have the responsibility of their profession also. The main aim is to retain women in the profession, come what may. So therefore, every woman must ultimately determine that even after she gets married, after she has children, she will return back to the profession. That is most important. Returning back to the profession means the profession has been able to retain that woman advocate in the profession. Once you return back to the profession after having your marriage and children, then your whole vision will be different and you will continue. There are, you see, what you call pulls. One pull is from the professional side, the other pull is from the family side. Therefore, they have to balance everything, and hence, I would say, when I was elevated to Supreme Court, I said, behind every man, every successful man is a woman, but behind every successful woman is a family. So the sum and substance is, have the determination to return to the family, to the profession after you have your family. That is the most singular advice.
Thank you. Thank you so much, ma'am. Next question, please. Yes.
Yes. Greetings to Honorable Justice Nagratna ma'am. I am Ananya Rao from second year. In a recent judgment delivered by your ladyship regarding right to privacy being inherent in children when questioned about legitimacy, what, according to your ladyship, is the current status of right to privacy of children in India?
Of course, I have explained in that judgment, if you see, what are the nuances with regard to right to privacy. See, many a time it is unfortunate that if a lady, that is the wife, files a case for maintenance for herself and the children, it's not always, but sometimes the husband will file an application saying the child is not mine and bring about the strain of infidelity against the wife. So the child is not mine, why should I pay maintenance to the child? Then in that case which you mentioned, a petition was filed to seek a DNA test on the child with regard to the proving of adultery by the wife. So we said, you cannot, unless you make out a prima facie case, that is, there was no access between the husband and the wife at all for procreating a child. The application did not make out a prima facie case for having a DNA test of the child. In that case, we also referred to Section 112 of the Evidence Act, where it says that if a child is born from the marriage of the man and the woman, it is deemed to be a legitimate child unless the man is able to say that he had no access to the woman. so as to procreate the child. But this kind of application using technology of the DNA test is not correct in all cases. I can give you an example. Suppose after marriage, immediately after marriage, the husband went abroad and the wife was remaining in India. And then there was no contact, no access, and the child is born, and the case for maintenance or something is filed. Then the husband can always say, I never returned for 2 years, I had no access to my wife, the child is not mine. In such a case, he can seek such an application, prima facie case. That is one clear example I have given. But if the husband and wife are living together, there is access between the couple, then on what basis you can have this, application filed for conducting a DNA test of the child? Now look at it from the point of view of the child. Imagine the child does not, if a DNA test is what is called directed by a court, that means there is a doubt cast on the paternity of the child. Mother is known because the child is born out of the womb of the mother. But who is the father? A doubt is cast. Imagine the child's confusion if it does not know who its father is, who is the biological father. And such a test being conducted to know who the father is. This is a right to privacy which we have said must be protected unless it is really a prima facie case where it is necessary to know who the father is. In such a case only we said the application should be allowed. Otherwise, the right to privacy of a child with regard to its legitimacy is a very important right. I have written about it, you please see. Adoption is a different matter. Adoption is always known because a child who is given from the biological parents to the adopting parents. But when husband and wife are together, why should this kind of use of science be made? It is a misuse, according to me, of science to have a DNA test on a child being performed and therefore creating a doubt in the mind of the child as to who its father is. That is an important right of the child.
Thank you, Your Ladyship.
Thank you, Your Ladyship. May we have the next question, please? Next question. Yes.
Greetings to Honorable Justice Nagratna, ma'am. My name is Charvi Devrakash from 4th year. Your Ladyship, what are your views on menstrual leave and how can it be transformed into a reality?
See, menstrual leave, it's a matter of policy. It has to be taken by the government and by the authorities who, I think in certain corporates, they are giving it. See, one aspect which I feel is if a leave is taken, it is either sick leave, casual leave, or earned leave, or whatever, these are the various categories of leave. But if you say a lady is taking menstrual leave, I feel in a way her right to privacy is also curtailed because that is something which should not be known, that a lady is, undergoing periods and therefore she is on leave. I think her right to privacy is there. That is one concern which I have. It should not be called as menstrual leave or anything. Many women who are lucky enough do not require that leave at all. But there are some women who would require it. So maybe for women, one way of looking at it is, instead of calling it period leave or menstrual leave, and on that particular day, the lady taking leave every month, making it very obvious, you can increase the number of casual leave, I suppose, for women, so that they can avail of that without giving any label to it. You can increase the number of casual leave for women, I suppose. Like more maternity leave is given to the woman than the father who has only, I think, 15 days of paternity leave. There is a distinction. Maternity leave is up to 6 months because she has given birth to the child. Therefore, one way of looking at it is increase the casual leave, and in such a case, the right to privacy of the woman is also protected, and if she wants, she can avail it. If she doesn't want, she need not avail it. That is one way of looking at it. But this is only my personal opinion. I'm not sitting here pronouncing from the bench. This is only a woman-to-woman talk. Huh?
Thank you, Your Ladyship. May we have the next question, please? Yes.
Greetings to Honorable Justice Nagaratna ma'am. I'm Rafi from third year. Your Ladyship, will robot lawyers argue in the courts in the future?
Pardon?
Will robot lawyers argue in the courts in the future, just like robot lawyers defend speeding ticket cases in New York City courts?
Robot lawyers.
Yes.
Yes, you may have, see, robots you have, I think in dentistry also they have now robots doing surgeries and other surgeries are also there. Of course, it is all artificial intelligence. But you see, in a court of justice, it is rule of law is one thing where you may have robotics, but justice cannot be through robotics. In every case, sometimes we may bend the rule of law to a bit, of course, within the four corners, in order to do justice. Doing justice in a matter it can't be on robotics. It has to be from the feelings of the judge as it arises from the assistance of the counsel. Ultimately, this is the computer and this is the computer which you must have. The qualities of head and heart.
Thank you.
See, for a judge, the qualities of head and heart and the pulse of the society, knowing the pulse of the society, are most important qualities. Thank you.
Thank you, Your Ladyship. Can we have the next question, please? Yes.
Greetings to Honorable Justice B.V. Nagaratna ma'am. I'm Sankirtana A from first year. Your Ladyship, my question is, what is your opinion on judicial activism in the present day scenario? Thank you.
See, judicial activism, as I spoke through my lecture, it increased since the 1980s. This is actually a reaction from the courts to the suspension of fundamental rights during emergency. And after the ADM Jabalpur case, the courts realized, especially the Supreme Court, that it is the guardian of the fundamental rights. And in order to achieve not only the enforcement of fundamental rights, but to achieve socio-economic justice in the country, to curb state lawlessness and repression, and to improve the welfare of the society, judicial activism is through the public interest litigation. That is the way I would call it. You can also be an activist while interpreting the law. It need not be in a public interest litigation. You can read various human rights, fundamental rights, even in the case of private dispute between the parties. Ultimately, activism is a good word, not a bad word. Judicial activism is to ensure that there is justice done in the court of law by giving an innovative and a forward-looking interpretation to statute, keeping in mind the latest developments in society and in the world.
Thank you. Thank you, Your Ladyship. May we have the next question, please?
Greetings to Honorable Justice Nagaratna ma'am. I'm Shrisha Hegde from first year. Do you think there is a requirement of reform in appointment of judges in India?
That is a topic which I would not like to speak much about. But you all know there is the first judge's case, second judge's case, third judge's case, and the NJAC is the fourth judge's case. So ultimately, everybody should work, whether the Supreme Court Collegium or the High Court Collegiums, who should work for the betterment of the institutions by getting good, meritorious judges to the courts. And similarly, the government must understand that the aim of the courts is to get good judges for the institution. There has to be a coordination between the courts and the government in getting the best, meritorious, talented judges to the courts, because ultimately we require good judges for the welfare of the citizens in the judicial, through the judgments.
Thank you.
Thank you, Your Ladyship. Can we have the next question, please?
Greetings to the Honorable Justice Nagaratna, ma'am. I am Radha Narayanan from third year. Your Ladyship, what do you think is the cause for low representation of women in the judiciary? Thank you.
See, as I told you, one of the, while answering her question, as I said, for women, women in judiciary, no? Yes. For women in the profession itself was, till recent times, women in the legal profession was very less. As I said, the pulls between the profession and the family would many a time make the women withdraw from the profession itself. That is why I say retention of women in the profession is very important. And for retention, you must have sufficient incentives to be given for women in the profession so that there is visibility of women in the courts of law, so that they are able to continue their profession for 50 to 20 years and improve their own standards from year to year, and ultimately create an impression in the court so that they are able to be chosen as judges. That is as far as the High Court is concerned. So therefore, visibility in the profession is important for women. For that, they have to pursue in the profession, return to the profession after their family is complete, even if they have taken off. And I may say now, one way of visibility being continuous is through virtual courts. You can have your baby and the cradle at the side and argue virtually in the courts. That is an important, you see, innovation, what you call a technology during COVID times. You can address the court from your homes or from your offices. Make use of technology and pursue your profession in the most serious way. And as a result, there would be greater women who would be retained in the profession. If more women are retained and continue to practice for 15 to 20 years, then they'll automatically, on merit, be selected to be elevated as judges of high courts. Now, as far as district judiciary is concerned, in Karnataka, we have some kind of a reservation for women. In the recent past, where I was in the High Court, in the selection of judges, district judges and the junior judges, many a times I found that there were more women being selected than men. That is because of their determination, their studiousness, they have pursued. And I hope such women continue to remain in the district judiciary so that they can ultimately be elevated to the high courts.
Thank you. Thank you, Your Ladyship. Next question, please.
Greetings to Honorable Justice Nagaratna ma'am. I'm Adya Anil from second year. Your Ladyship, do you think that there should be more benches of Supreme Court established in the country to make the apex court more accessible to all the corners of the country? Thank you.
You ask more branches.
More benches.
Benches. No, personally speaking, this is my personal opinion that there should not be splitting of the Supreme Court in various zones, or so to say. The court must remain in one place. It is the integrality of the court which is important. And now this distance has virtually been removed because of video conferencing facility. You can mail your cases through emails to the Supreme Court. Then you can appear in the Supreme Court virtually from wherever nook and corner of India, thanks to COVID and improvising technology. Therefore, I think this distance from, you see, access and distance is gradually coming down. At least this COVID has helped us in removal of this obstruction of distance as a negative factor. And therefore, the court, according to me, my personal opinion, should be in one place and not split into different benches.
Thank you. Thank you, Your Ladyship. Can we have the last question, please? The last one. Yes.
Hello. Greetings to Honorable Justice Nagaratna, ma'am. I am Abhishek Bharti from 4th year. Your Ladyship, aim the rising trends of litigation. More people and organizations are approaching courts and the burden of cases are increasing. How is the judiciary maintaining a balance regarding the pending cases?
See, as far as pending cases are concerned, we have already started what is called alternative dispute resolution. Please sit down. Alternative dispute resolution mechanism through mediation, arbitration, conciliation, Lok Adalat, where cases could be settled. They could be settled through these mechanisms outside the court. But there are certain cases which cannot be settled through these kind of mechanisms. They remain in the court. See, my advice to all advocates and lawyers and the future lawyers is to resort to the alternative disputes mechanism and to bring about a settlement in the cases, not through the judicial process, but through the alternative process. See, sitting as a judge, I find that the most satisfying order that I can pass is an order on compromise between the parties. Not because I don't have to exert in writing a judgment and giving my reasons, but if the parties settle their dispute amongst themselves through mediation or compromise or conciliation, then that is the best order that a judge can pass, because the judge would feel that the parties are satisfied with the settlement that they have arrived at. So that is one way of bringing down litigation. Secondly, it is the duty of the advocates also to ascertain whether it is a fit case to be filed or not to be filed. That is an important role of the advocates. Thirdly, when it goes up to appeals, whether these are good cases to file appeals or not to file appeals. Every advocate always thinks that a chance could be taken before a higher court. I'm sure if there was a court above Supreme Court, there would be again cases filed to that superior court, because the litigant public always wants to take a chance. That kind of a thing must not be there. The role of lawyers in ensuring that only good cases are filed and advising the client that it is not a case worth fighting for is very important, I feel. Then there will be a lessening of the litigation. Secondly, alternative dispute resolution process. Thirdly, by technology, we are able to bunch cases of the same point so that with one judgment, many cases can be decided. The similar cases, bunching of cases, we are able to do with the help of technology. That must be followed in all the courts. But you see, with the explosion of population in the country, there is bound to be an explosion in docket explosion or litigation also. There are bound to be such cases. Laws are being made, more rights are being given to the citizens. So therefore, there would be more enforcement of such rights. One way you look at it, it is good, because people are having access to justice. The cases are not getting settled on public streets, but through the mechanism of the judiciary. But at the same time, the judiciary is overburdened. Judges everywhere are working hard, and the cooperation of the bar is required. The cooperation of the litigant public is required to ensure that the cases are decided at an early date and not lingered. Thank you.
Thank you. Thank you so much, Your Ladyship, for very patiently answering all the questions posed by our young lawyers here. On behalf of PES Group of Institutions, we would like to felicitate Honorable Mrs. Justice B.V. Nagratna, as a token of our respect and gratitude, may I request our Honorable Chancellor, Professor Dr. M.R. Doraiswamy sir, and Professor D. Jawahar to honor and felicitate her ladyship. And I request all the dignitaries to join them. And let us give a standing ovation to our chief guest today, Honorable Mrs. Justice B.V. Nagratna, for taking out her time and inspiring all of us here. As truly said, she would become the first woman Chief Justice of India in 2027, a true inspiration to all of us here, not just the law students, but all of us here. Let us give a huge round of applause and felicitate our chief guest. Thank you. Thank you, sir. Thank you, Your Ladyship. Thank you, sir. Thank you, Your Ladyship, for accepting our token of gratitude. May I now call upon Dr. Shailashri Haridas, Advisor, Faculty of Law, PES University, to deliver the vote of thanks.
Thank you so much. Ladies and gentlemen, it's my privilege to propose vote of thanks to Your Ladyship, Honorable Justice Madam Nagratna, Judge, Supreme Court. Ma'am, you are truly an inspiration for all women seated here. Thank you so much for accepting our invitation. I'm sure there is no need to talk about women empowerment anytime in India henceforth, right? We all have seen the personality like ma'am, and we are sure you are the role model for all of us. Thank you so much for taking out the time. And as I just mentioned, ma'am is a role model. She has exhibited that, the lawyers can have the ability to change the injustice to justice and weakness to strength. Please give her a big round of applause for all the things which she has done today. Thank you so much for being here and advising all our students of Faculty of Law, PES University today. Thank you so much. My sincere thanks to Professor M.R. Doraiswamy sir, Founder Chancellor, Advisor to Government of Karnataka for sharing his thoughts. Sir, you are a Preranalaya for all of us. Thank you once again. Thank you so much. My special thanks to Professor Jawahar, Honorable Pro-Chancellor, Captain of the ship. I always feel that, the future belongs to the one who believes in the beauty of their dreams. And whenever I talk to sir, I always find the vision in all the thoughts or all the speeches which I always hear. So thank you so much for being here. Thanks for all the support. Thank you so much. I'll fail in my duty if I don't thank the Honorable Vice Chancellor, Dr. Surya Prasad, and Professor Ajay Kumar, CEO of PES University, who always helps us in all walk of life. My sincere thanks to Registrar sir. Sir, thank you for gracing the occasion and for all the needful things here. Thanks to the press and media and the police for supporting us. I request you to continue supporting us like this. Thanks a lot for all the support. And my all thanks to my colleagues, faculty members, students, deans and chairs of the sister institutions for their presence and making this program a big success. A special note, I would like you all to listen to this. A special note of thanks to Honorable Justice Shri Srishananda, Judge High Court, Karnataka, who is not present here today. Please give him a big round of applause, who helped us to curate this program. He couldn't come here because of the other official commitments, but without him, this program would not have happened as such. He's a person behind curating this particular program. Special thanks to all the students and the volunteers. Student convener, Mr. Raghu, I hope he's somewhere here. Raghu is here. Special thanks to him. Please give a big round of applause to him. It's always the students and the alumni and the faculty member who makes the institution, and I'm sure having the students like you all will be really an asset for all of us in order to build the institution further. Thank you once again. Thank you all. Jai Hind, Jai Bharat.
Thank you, ma'am. May I now request all of you to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Request all to be seated till the dignitaries leave the auditorium. Request all the students to be seated till the dignitaries leave the auditorium. Let's show our respect and gratitude by standing till the guests leave the auditorium. Silence, please. For your kind information, the next session begins at 1:45 sharp. The law students should remain in the hall. Let's give one more huge round of applause to all the dignitaries, our chief guest, Honorable Mrs. Justice B.V. Nagaratna, our Honorable Chancellor, Professor Dr. M.R. Doreswamy sir, Pro-Chancellor Professor D. Jawahar sir, Registrar Dr. K. Sridhar sir, Advisor Faculty of Law Dr. Shailashri Haridas, all directors and deans who grace this occasion today. Thank you. The second and the first floor students can leave first. Law students will remain seated. The first and second row students can leave first. The law students will remain seated till the mentors are taking account of the attendance. The lunch is planned from 1 to 1:45. The next session starts sharp at 1:45. Request all the students to be back by 1:45 and be seated at the MRD auditorium. Request the mentors at Faculty of Law to take account of your mentees attending the session today.